deliberations on the bill. In the meantime, we shall call on all political parties to apply their minds on the substantive issues raised in the report and seek mandates as we shall from their principals, as we shall be embarking on deliberations on the bill to ensure that we meet the May 21st deadline. We are delighted, therefore, that Honorable Minister Patricia de Lille is here and should be able to enlighten us on the management of the expropriation bill and how it dovetails with our process. We are also delighted that Honorable Minister Gwede Mantashe is here, because we cannot talk about land without its natural resources. We have no doubt that the Honorable Minister Gwede Mantashe is able and willing to enlighten us on these matters, to empower us to deal with the bill. The Department of Justice is also here, and they will also throw light on the work they are doing to transform the Land Claims Court, because that court plays and should play a central role in the law reform process. So, honorable members, I have no doubt that you are ready now to receive the briefings. Members, we have been requested by Minister de Lille that she wants to come first because she has other engagement. So we will allow her to address us, followed by Honorable Minister Gwede Mantashe, and then the Department of Justice. Honorable Minister de Lille, are you there?
Yes, I am, Chairperson, and thank you for the opportunity. Good morning to the honorable members, honorable Chair. I first want to start with an apology, Chairperson, for the misunderstanding in the last meeting. We are here to correct that today. And then, Honorable Chairperson, also an apology from our Deputy Minister Kivit. She will join us a bit later. Honorable Chairperson, Professor, as per the invite of the ETA Committee in terms of Rule 275B of the National Assembly, you've invited us to give the relevant departments, excuse me, an opportunity to make some submissions. So the committee invited the Department of Public Works of Infrastructure today to present our views. Honorable Chairperson, the relevance of the Department of Public Works and Infrastructure is that the department has drafted the expropriation bill that was submitted and gazetted submitted to Parliament in 2020. We are here to engage with the committee on how the proposed amendment to the Constitution will impact on DPWI as the landlord, as the custodian of state-owned properties and land. We also understand that the committee proposals is trying to make explicit what is in the Constitution, and therefore the committee proposals will help the Department of Public Works and Infrastructure in that its implementation of the expropriation bill. Briefly, under just an introduction, Chairperson, to the bill, the expropriation bill, the right of government to expropriate private property for public use and public interest is a worldwide practice. And in our research, we've looked at many countries. It's called different names. In the USA, it's called eminent domain. You also have it in the UK, New Zealand, Australia, South Korea, Singapore, Ethiopia, Rwanda, Brazil, Mexico, Chile, France, Norway, and also Germany. And there are many other examples. So South Africa is no different from the rest of the world. Currently in South Africa, Honorable Chairperson, expropriation occurs under the 1975 apartheid era Expropriation Act. And this act is inconsistent with the 1996 Constitution. We all know that in 2019, the report from the Presidential Advisory Panel on Land Reform and Agriculture determined that the current Expropriation Act 63 of 1975 should be urgently repealed as it's not aligned to the Constitution. So the purpose of the expropriation bill from DPWI is to align legislation with the Constitution and also to replace the Expropriation Act of 1975. To quote the Presidential Advisory Panel on Land Reform, the panel draws the attention to the use of the Expropriation Act 63 of 1975. And they said, Chairperson, as the Act precedes the 1996 Constitution of South Africa, its use does not align with the transformative mandate of the Constitution. And the panel then proposed, like I said, the speedy replacement of this Act, and therefore the drafting of the new proposed Expropriation Act of 2020. Also, the current 1975 Act does not address redress, like it's specified in Section 25(8) of our Constitution. So our mandate was to review the Expropriation Act, but the history of this review, Honorable Chairperson, started with Cabinet approval on the 15th of September 2004. And then thereafter, 2 iterations of a revised expropriation bill were tabled in Parliament. A 3rd iteration of the Expropriation Bill 2019 was published in the Government Gazette for public comment on the 21st of December 2018. We received about 50,000 written responses and they were considered. And then on the 9th of October 2020, the bill was introduced into Parliament. Chairperson, I briefly just want to highlight certain sections of the bill because the bill seeks to repeal the Expropriation Act and to provide a general law of application in line with the Constitution to guide the processes and procedures for expropriation of properties by the organs of state. Currently, we have the powers to expropriate is with the President of the country, at least 7 national ministers, all the premiers of the country, and all municipalities. So therefore, it was necessary to provide an act for a general law of application in line with the Constitution. I further note again what the Presidential Advisory Panel on Land Reform and Agriculture pointed out, that, like I said, it's inconsistent with the Constitution, and the correction of this has been long delayed. And that the panel also pointed out that the 1975 Act undermines the constitutionality enshrined principles of lawful, procedurally fair, and a reasonable administrative justice. Also, we think, Chairperson, that the expropriation bill will bring certainty to all South Africans, to investors, because it clearly outlines how expropriation can be done and on what basis. It also provides for instances where expropriation with no compensation may be just and equitable. So just briefly, clause 12.3 of the bill, Chairperson, no compensation is dealt with in that clause. And it states that it may be just and equitable for no compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances, including but not limited to, where the land is not being used and the owner's main purpose is not to develop the land or use it to generate income, but to benefit from appreciation of its market value. B states where an organ of state holds land that is not using for its core functions, and it's not reasonably likely to require the land for future activities in that regard, and the organ of state acquire the land for no consideration. C says, notwithstanding the registration of ownership, in terms of the deeds regimes of 1937, Act 47, when owner has abandoned the land by failing to exercise control over the land, where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. And lastly, E, when the nature or condition of the property poses a health and safety or physical risk to persons on the property. I just want to highlight also another section of the bill that states that in the event of a dispute of the expropriation or the offered compensation amount, the courts will be the final arbiter. And that is in chapter 16 of the bill, but it's also aligned to section 34 of the Constitution that says that the court will be the final arbiter, because section 34 of the Constitution states that everyone has the right to have any dispute that can be resolved by the application of law in a fair public hearing before a court. So lastly, Chairperson, I want to share with you just one case study that where we had to apply the 1975 Act. We have got a case in Untitled in the Eastern Cape. In 2015, Eskom applied to expropriate a servitude to run power lines over a farm to supply power to a nearby township. Chairperson, it took 6 years for the matter to be finalized. The court had to compel the expropriation. Eskom applied on the 24th of April 2015. The minister approved the application on the 30th of September 2016. Then the owner lodged a review application in March of 2017. And then in September 2018, the review application was dismissed and judgment was granted in favor of the department by the High Court. Then the owner then turned to the Supreme Court of Appeal in March 2020, where the appeal was dismissed. The owner really demanded 3.7 million rand for the land that we want to expropriate. However, the courts upheld the sum of 1.294 million, that it was appropriate and a reasonable compensation for the land. So that is just one case study that we can make a reference to. Just in conclusion, Chairperson, again, I'll go back to the Presidential Advisory Panel on Land Reform and Agriculture. Like I said, that the 1975 Apartheid Era Act is inconsistent with the Constitution. It undermines the constitutionality. And then the purpose of the expropriation bill is then to repeal the 1975 Act. And like I said, the bill also draws circumstances where no compensation may be equitable in clause 12.3, and that the courts will be the final arbiter. And just to add, Chairperson, that the bill currently before Parliament has been certified by the Chief State Law Advisor as being constitutional. So, Chairperson, for us, that is the relevance to the work that the committee is doing. We certainly support the work of the committee because it will assist us as a department to bring more clarity, and we look forward to the outcome of this process. I thank you very much, Chairperson and honorable members. You are muted, Chair.
Thank you, Honorable Minister, for a short and sweet presentation. I just want to draw your attention to one matter, which may not be directly relevant to the bill. There are critics of the department who say that the department is the landlord, but doesn't seem to know where the lands, farms, and properties are, and some of them are underutilized, some have been hijacked or invaded, and now where people want to have recourse to the courts to gain access to this land. But now the Land Claims Court doesn't have full-time judges, and people are worried that they can't have any remedies from that court. The question therefore is, do you have an audit of farms and properties under your control, which don't even need expropriation, but which the department can simply transfer to communities which need the infrastructure for development and other purposes? Thank you.
Thank you, Honorable Chairperson. That, in fact, is not true. Government has done 2 land audits in the past to establish what land is available for the landless, for the people that are hungry for land. And then the first audit was to determine the amount of land owned by the state or in private sector ownership. And the second was to determine what was privately owned. So these are the outcomes of the audits. The 2013-14 land audit found that 79% of South African land was in private ownership. 14% of the land is owned by the state, and 7% was unaccounted for. The second audit found that individuals, companies, and trusts have a combined ownership of 90% of the total land that was audited. And the audit also reveals, Chairperson, that whites own 72% of the land, followed by coloureds 15%, followed by Indians at 5%, and blacks at 4%. And then there was another unidentified by race, about 3%, and co-owners at about 1%. So we are working from a scientific audit, and we know exactly what land is owned by the state. But also, Chairperson, in terms of government's key land reform program that focus on land redistribution, land restitution, land tenure, a lot of things have happened over the years. You've just seen recently that Minister Tokadadisa has released over 700,000 hectares for agricultural purposes. Yes, the land reform has been slowed, Chairperson, but there is now a commitment from government to speed up land reform. So it's absolutely not true to say that we are working from a base that we don't know how much land is owned. What we do need to do in future, Chairperson, some of the land is owned by national government. Some of the land is owned by the provinces, and some of the land is owned by municipalities. We need to combine all of the land of the whole 122 million hectares of South Africa's land. And then that will help us to speed up land reform, instead of just looking at the land that's owned by national government. And if we can achieve that, and we can all work together as South Africans, accepting that 79% of the land is owned by the private sector, then I think we can have a solution, Chairperson. Thank you.
Thank you, Honorable Dilil, for that explanation, because the criticism may come from ignorance. And I hope that your explanation will help to deal with that situation, but perhaps also that if this information can be made available to public representatives, so that when these criticisms are brought to them, they are able to explain to the people. But thank you very much for that input. Honorable members, I want to open the floor for questions of clarity to the Honorable Minister.
Mr. Chair, I've raised my hand. It's Glynis Breitenbach. Good morning.
Mapula, how are you?
I'm well, thank you. How are you?
Well, thanks. Proceed.
Thank you very much. Good morning, Honourable Minister.
Good morning, Honourable Member.
I may have misunderstood you, so this is just to ask you to clarify for me, please. You said that the latest audit was, and you gave the figures, and you said of the land that was audited. I'm not sure what that means. Does that mean the entire land in South Africa was audited, or was there limited land audited? I just want to understand that. Thank you.
Sorry, let me take other hands before you answer. Honorable Shibambo.
No, thank you, Chair. I want to understand the Minister's approach to this expropriation bill. You are saying you want to align the expropriation bill to the Constitution. And the Constitution which you want to align it to is being amended now. This process that we're engaged in here is to amend Section 25 of the Constitution. So if you are currently, the Portfolio Committee on Public Works is currently conducting public hearings, meaning that if we have not finalized this process ourselves, they are going to align the legislation to the current Constitution, which is being amended now. Don't you think that we're putting a cart before the horse in terms of this process? Can't we wait for this process of amending the constitution, and then we later on align the expropriation bill as the enabling legislation, as the general law application law, which the constitution says must be enacted to deal with these issues. I think the priorities are not proper in terms of what is happening now, because we are amending the constitution and then you want to align the expropriation bill to a constitution which is being amended, and it doesn't make sense at all.
Thank you, Honorable Shibambo. I don't see any other hand. I will allow the minister to respond.
Sorry,
to
Chair. Sorry, Chair. My hand was up, Swart. Just very briefly.
Okay. Oh, yes. Now I see your hand, Honorable Swart.
My apologies.
No problem, and it's good to have you here. Proceed.
Thank you. I'm just keeping I've got a problem with connection, so I'll keep off the video. But thank you, Honorable Minister. I just wanted to ask, and these are just questions of clarity, just as far as the allegations against officials who might abuse powers, or will there be sufficient criminal steps in the bill to address that issue where you have officials which abuse their powers when it comes to expropriation? Is that something that has been considered? And then secondly, you correctly referred to the land which is in the hands of the state at a national, provincial, municipal level. Have you also taken into consideration the land that is owned by state-owned enterprises? We're all fully aware of the land that was handed over to Transnet, for example, at a very reduced, I think it was R1, the hundreds or tens of thousands of hectares of land, or whatever the figure is, that was handed over to state-owned enterprises. And I think that you make a very valid point that is a very important aspect that needs to be looked at when one looks to redistribution of land. Thank you so much, Minister.
Thank you. Is there any other hand that I haven't seen? If none, I shall ask the Minister to respond to the three questions.
Thank you, Honorable Chair and Honorable Members. To Honorable Glenis Breitenbach, the way I read the audit that was done in the financial year 2013-2014, it looked at 122 million hectares of land, which is the total size of the country. And I will certainly, Chairperson, make those audits available to the honorable members. Honorable Shibambo, if I can explain that these are two separate processes, but both processes finally end up in Parliament, where Parliament will make the final decision. Like I explained, the history of the Expropriation Act of 1975, there were several attempts started in 2004 to repeal this act because it's unconstitutional. And that is necessary because we cannot have a constitution that's transformative, but you're sitting with an act of parliament, an apartheid era act of 1975, that we are forced as government to use because it's still on the statute books. So the work of the Honorable Ad Hoc Committee is to look at the amendment of Section 25. And like I said in my introduction, I see that, and I understand that the work done by the committee and the proposals that the committee are discussing is trying to make explicit what is in the Constitution already. Expropriation is already in the Constitution. What the expropriation bill seeks to do is to put in a general law of application that can be used by all the three spheres of government to do expropriation. So I don't see that these two processes are mutually exclusive. I see that the two processes complement each other. If Parliament finally takes a decision to amend the Constitution to make more explicit what is already contained in the Constitution. That will also certainly help the department. To Honorable Member Swart, yes, we are also looking at state-owned entities and their land. I just raised it a few weeks ago because the one area where we have not done very well as a nation is to deal with spatial justice. We need to start integrating our cities, our towns. We need to make available well-located land where we can bring people closer to work opportunities. Our spatial pattern has been to take our, especially the poor and the vulnerable people, further and further away from the central business districts. The impact of that is that the poor people spend almost 40% of their income just on transport to commute. So we must deal with spatial justice and integrate our cities. Now, to answer your question, I'm now engaging with the Minister, Pravin Gordhan. I have set up a meeting with him to look at well-located land owned by state-owned entities. And they have got good located land. Transnet has got a lot of land. Transnet has got a big portfolio with well-located land. You also have Eskom, you've got PRASA, you've got the post office. So the state-owned entities must be drawn into the land reform program so that land can be released from the state-owned entities to help government to drive land reform. We can't have state-owned entities just keeping the land on their balance sheet, but the land is not being used. So under the leadership of Deputy President Mabuza, he is now going to convene a meeting. Honorable Chairperson and Deputy President is going to convene a meeting with all the state-owned entities. We have already requested that they make available what land parcels they own and where, so that we can also include the land of state-owned entities in the broader government land reform program of land redistribution, land restitution, and also land tenure. Thank you, Honorable Chairperson.
Thank you, Honorable Minister. Honorable Dr. Melder.
Thank you, Chairperson. Good morning, colleagues. Good morning, Honorable Minister. I just have two questions. I would like to go back to the question asked by the Honorable Breitenbach. If I understood the Minister correctly, she referred to two audits. She referred to the first audit done in 2013, 2014, I think, and she also now referred back to it. But then she mentioned that there was a second audit, and she said of the land audited, and then she gave certain figures. And if I remember correctly, more than 90% then she indicated was owned by white people. Now that's correct. Then that would mean that the total land reform process up till now was a total failure. So what I need to understand is she then said, but it refers to the 2013-2014 one, and that was the total area of South Africa. But I think there's a second audit, and I just want to understand when she says of the land audited, what does that mean? Is that a separate process? That's the first one. Secondly, I think it's historic, if I may say that in lighter vein, I agree with the Honourable Shivambu, because it does not make sense to me the two different processes at the same time. I understand that the current law in front of the bill in front of the Department of that the Minister is responsible is dealing with the current constitution. But if we now amend the provision of Section 25, then it means that the new Expropriation Act will then once again will have to be amended, or there will have to be another new Expropriation Act in terms of whatever the process that we are busy with will have an end result. So I just need to understand that. Thank you, Chairperson.
Thank you, Honorable Dr. Melder. And You will be followed by Honorable Dr. Mbuyiseni Ndlozi.
No, thanks. I'm covered.
Thank you, Honorable Doctor. I don't see any other hand. With your permission,
Sorry,
then.
Chair. Sorry, Chair. Swartia, could I just ask whether the Minister could answer just the issue about officials who abuse their powers, whether there would be any clause in that, if as a matter of clarity? Thank you so much.
No, you are right, Honorable Swart. I think you did put that question. Honorable Minister, can you address that?
My apologies, Honorable Member Swart. The way the bill is drafted, where we are really putting out clear procedures and processes as to how expropriation can be carried out. And in that process, there are also checks and balances built in. But in the event that, first of all, any official abuse his or her powers, that must be dealt with in terms of the Public Service Act, which we will certainly do. But the final arbiter, people can always turn to the courts. I know that we are a very litigious society and we use the courts often, but you know, for as long as we have got an independent judiciary and a credible independent judiciary, I've always put my faith in the judiciary to help us as a country, not only to heal, but to seek a justice. So my apology for that. Honorable Dr. Mulder, maybe I didn't make it very clear. The second audit was done in 2017. And the 2017 audit was just on urban land. And I did not say whites own 90%. I said what it showed was that the audit reveals that whites own 72%, followed by colored people of 15%, Indians of 5%, and blacks 4%. And then there was also in the urban area, other unidentified by race, which accounted for 3%, and co-owners accounted for 1%. But I will certainly make both of the audits available to the members. And then these audits were done by the Department of Rural Development and Land Reform. They undertook the two audits to look at the extent of land dispossession and also the extent of apartheid force removals. So I will make that available to the members. I just want to repeat what I responded to Honorable Shivambo. I don't know why you are panicking and why you're saying that the one process must follow the other. You are going to come with proposals on the amendment of Section 25 to Parliament. We have submitted an expropriation bill to Parliament in October of 2020 to repeal the 1975 apartheid expropriation bill. And it's the members of Parliament that will make the final decision. So because the repeal of this unconstitutional act that is still on our statute books, it is the role and function of the executive to make sure that we repeal that act. So there's nothing wrong on us repealing any act that is inconsistent with the Constitution. Unless, you know, we want to keep the 1975 Act, then first amend the Constitution, then thereafter come with the expropriation bill. There's no need to work like that. It's not mutually exclusive. It deals extensively in the Constitution, Section 25. And the expropriation bill that we have submitted to Parliament, the Chief State Law Advisor has confirmed that it is constitutional. So there's not one process follow the other, but the final decisions will be made by you, honorable members of parliament, whatever we do with the bill or with the amendment to the constitution. Thank you.
Honorable Minister, last but not least, with regard to Honorable Schwartz's question, I think we accept that you are not a lawyer, but I think what he seeks to find out from you is
Yes.
whether or not the expropriation bill that you are currently busy with should not criminalize or attach criminal sanctions to abuse of power by officials, and whether leaving those matters to the Public Service Act is adequate. I'm just trying to
Yes.
rephrase that to assist you, because
Yes.
Honorable Swart is a lawyer and he thinks that everybody is a lawyer.
Thank you. Thank you. Thank
for
you,
the
Honorable
assistance.
Chair, for the help.
Okay. Yeah, proceed. Honorable Minister, are you still with us?
Yes, I'm still with you. I was just saying thank you for the protection, Chairperson. I'm not going to attempt to be a pseudo lawyer, but you know, whenever there are questions that are asked to me in Parliament, I can always also answer those questions. Thank you, Chairperson.
Okay. So you are done.
I'm done, Chairperson. I
Okay.
maybe just lastly want to say to the committee that government is committed to restitution, redistribution, land tenure, as recommended by the advisory panel, and that expropriation is just but one mechanism of acquisition of land, but it is part of a total package of land reform that government is driving at the moment. I thank you, honorable members and honorable chair.
Thank you, Honorable Minister. I think you would not mind if people who have who come to us have questions that we refer them to you, because
Yes.
we don't want to see the government being taken to court unnecessarily on things that can be easily resolved. Thank you very much for your attendance, and you are well excused.
Thank you very much. I will stay until 11 o'clock, Chairperson, so I can listen to the other ministers too, with your permission.
Oh, wow,
Thank you.
wonderful, wonderful. That's a good collegial spirit. Honorable Minister Gwede Mantashe, the former mayor of Ikala, are you here?
I'm here at Matter.
The platform is yours, and we are really happy to have you here in a different capacity. Proceed.
Mayor of Boksburg for 3 hours at the Matter.
Or not Ikala, eh?
3 hours only. I was never after more than that.
No, I think you were well groomed by that position to deliver in your new position.
Thank you very much, Dr. Mator. So when I was invited to come to the ad hoc committee, that looks into the initiation and introduction of legislation, amending Section 25. I asked many questions. So, we're not dealing with land, they were dealing with things under the soil, under the surface of the soil called minerals. What is on surface is out of our jurisdiction. But I accepted to come here. Thank you very much. One, welcome the opportunity, and our submission to Constitution 18th Amendment Bill, the main objective of the bill, from our understanding, is that this bill should be fully supported. So we support your work fully because we see it as seeking to provide that the right to property may be limited in such a way that where land is expropriated for land reform, the amount of compensation payable may be nil. It may be nil. So we support that. And such limitation must be regarded as a legitimate option to land reform. The bill in its current form will bring much needed legal certainty in that it explicitly states what is already implicitly provided in Section 25. So in other words, the reason that we support this was that many of the people say Section 25 doesn't restrict expropriation. That is implicit. Now the intention of the bill is to make that explicit. So we support that. The coexistence in Section 25 of the constitutional protection of existing property rights alongside the constitutional imperative of redress through land-related reform is perceived by many as anomalous. And we think that this process is going to address that anomaly because overemphasis on the protection of property rights is an anomaly if it is put against the need to redress through land-related reform, and therefore that anomaly is going to be addressed in this process. However, Section 25 in its current form already permits the enactment of implementation of restorative legislation without compensation obligation. As I said, it provides for that, but in the majority of cases it is implicit. It's now going to be made explicit. And since the commencement of the Constitution, legislation such as the National Water Act and the National Environmental Management Act have been promulgated to vest the country's natural resources under the state custody. The Mineral and Petroleum Resources Development Act of 2002, Act number 28, is a profound example of restorative legislation. Now, through its enactment, land and related reform has been achieved by providing for vesting the nation's mineral resources under the state custodianship without the obligation to pay compensation. In other words, the ownership of mineral resources below the surface of the soil reverted to the state on behalf of the people as a whole. No compensation is payable for that. Confirming the legitimacy of this regime, Constitutional Court in Agri SA cautioned against overemphasis of private property rights at the expense of the state social responsibility. Therefore, whereas Section 25 in its current form already implicitly provides for circumstances where compensation of nil will be just and equitable, the bill now explicitly provides that the right to property is not absolute, and that where land is expropriated for land reform, the amount of compensation payable may be nil. Therefore, our conclusion is that the bill and its main object to accelerate land and related reform is supported by our department and ministry. It brings long needed legal certainty by clarifying the existing anomalous relationship between absolute protection of existing property rights and state restorative obligation to redress past injustices through land and related reform. That is our brief submission that, as I said, we're dealing with things that are below the surface of the soil. We want to give space to the land issue to the relevant ministers and departments. Thank you very much. You're muted, Dermato.
I say thank you because I've just learned that sometimes non-lawyers are able to explain the law better than lawyers. You know, we sit here, we say we make explicit what is implicit. That is still legal jargon. And Honorable Gumede here helped us to say, no, we're talking about legal certainty. And you have really vindicated Honorable Gumede, and we are grateful for that. My one question to you, Honorable Minister, is that there are some communities which believe in African religion who have sacred sites at which they practice their religion. And their concern is that there are mining companies who are given licenses to the state, by the state, to mine where their sacred sites are located, like Mapungubwe, which is also a World Heritage Site, and that these mining companies don't really respect the religious rights of the people, which are guaranteed by the Constitution. Is there anything that you do in the awarding of these licenses to make sure that the religious rights of indigenous African people are protected, or to create a balance between the economic developments and the religious rights of the people?
One of the processes followed before we issue a license is consultation of those communities. And the reason that consultation is an imperative is because communities in each area that is identified for mining should have a say on the issuing of license. That's why when the judgment was given that we must get consent of the communities, we have no problem with that. All we wanted is clarity on absoluteness of that consent. But to get the majority support of an application, we are supported and accepted. And the reason we accepted that is many reasons, including the one you are stating. But let me state that now practical experience is that half the time we don't have a problem in the process of applying for a license. We normally have a problem once the license is given, because once the license is given, then you begin to see people who want to get that access to that well for the sake of being where they are located, and not want to work for that well, which is creating a lot of contradictions. And I must add that we go to all areas, you see a small group of people representing that community, and greed takes over. That small group take over the rights that belong to those communities. Thank you.
Thank you, Honorable Minister, for clarifying that and to help us to respond to questions as public representatives. Honorable members, I want to open the floor for any other questions of clarity. I see Honorable Noko Masipa and Honorable Shibambo. Proceed, Honorable Masipa.
Thanks, Chair, and thanks, Honorable Minister Mantashe. You are very clear, Minister Mantashe, about the compensation that it may be nil. My question to you is that where a nil is being considered, do you believe that the court must, it must be a ministerial function or a court function in the determination of that? Thank you, Minister.
Thank you, Honorable Masipa. Honorable Shibambo.
No, thanks, Chair. So now the Minister of Public Works has just illustrated something that is a worrying factor, that when there was an attempt to implement the expropriation bill, the Section 70, well, the 1975 expropriation bill, it took more than 6 years to just expropriate one piece of land in the manner that got to happen in Eighteenth. It's an interesting, so whether it is done through a court or through by an executive authority, there's litigation that follows after that in terms of what gets to happen. Don't you think that we should do to land what was done to the mineral rights, where we then say that the state is going to be custodian of all of South Africa's land, and then we'll redistribute it equitably? Because if your approach is the one of expropriating small pieces of land, one and piece by piece, the fact of the matter is that 100% of the times you're going to face litigation, and courts will be swamped with that particular process of trying to listen to people saying, why am I not being compensated? This land belongs to my grandfather, and all of those other things there. Don't you think that if we take an approach that still retains a piece by piece expropriation, we're just like circling around, we're not going to achieve anything? So a better approach could be to repossess the entirety of South Africa in the manner which we had repossessed all water through the Water Act of 1998, and through in the same way we've repossessed the minerals through the Minerals and Petroleum Resources Development Act. I think that is a much more dependable and durable process in terms of how we can then deal much more sustainably with land redistribution reform and land tenure that has to be secured for a lot of people that do not have security of tenure. That is the perspective. Minister, please give your response to that.
Honorable Minister.
Yes, the question of determining compensation should both be a ministerial responsibility and court, in the sense that in the process of allocating land and determining compensation, a relevant minister will determine that it will be at no cost, nil compensation. But the courts come in the fact that they are the final arbiter when there's disagreement. So I don't think it should just go straight to the courts. It should be part of the processes. I enjoy that in mineral resources, in the fact that when you talk of consultation, many people take it for granted that it's a simple thing. It's quite a difficult thing, because sometimes you get involved into a long process, trying to ensure that the community concerned is also equally educated about the processes. But if there is disagreement, courts are the final arbiter, and we must all accept the decision of the courts. So that's why I say it's not a watertight ministerial or court. It's ministerial, but ultimately it will end up in courts. On the question of land, reverting the ownership of land to the state on behalf of people as a whole, as it is with minerals, I don't want to pretend to be an expert on that, but I must say that in 2004, I was not a minister then, when we were involved in this debate of the ownership of mineral rights reverting back to the state. We were guided by the Freedom Charter. and we worked together with the governing party at the time to have this legislated into law. And it is comfortable to me. That's why the point of applications for any private mineral company is quite an important and involved process. I don't know in the case of land, because land is too complex for my understanding, Honorable Shubham. It's too complex for my understanding. Because when you have a piece of land, I normally respect land for production. I know that is not the only use for land, but I like it for production, because when you take my land and I'm producing, I've added value, I've improved it, there should be a discussion with me. It can't be the responsibility of the state, because I do that with value. And my short experience in that area and the rest of them is that when you give a piece of land to a group of people, half the time it doesn't become productive, because people procrastinate, who will plow there, who will plow that. So you have that piece of land, it's yours, you produce optimally in it. So I'm not giving you an exact answer, but I know that it works in the case of minerals. I don't know in the case of land. I'm not knowledgeable in that area, except as a farmer.
Honorable,
That is why we asked for a meeting with you, National Chairperson.
Honorable Shibambo,
I will give you your answer when you come.
We don't want to deal with your bilateral meetings in the committee, so proceed offline with those bilaterals. But I think the opinion that you raised and the response you got belong to the battle of ideas which will take place in the committee at our own time. But thank you very much, Honorable Minister, for engaging with us. I don't see any other hand. That means your input was quite clear, and it will empower us as we move forward. You are well excused.
Thank you very much.
Honorable Advocate Ramano or Gwebu, is Department of Justice here? Department of Justice? Advocate Ramano, Department of Justice? Are they here? Hello? Honorable Shibambo, do you want to say something?
Yeah, no, I want to say something. Why, where is the, before they speak, where is the Minister of Justice and Correctional Services? Because
Honorable Shibambo, that's an unfair question.
Because the other ministers were represented by their ministers.
Honorable Shibambo,
so where is the Minister of Justice and Correctional Services?
Honorable Shibambo, that's not the right way of doing things. Let them come to the platform. They will tell us why the minister is not here. Who is here from Justice? Honorable Ramano?
Chair,
Advocate Ramano?
Mr. Dupria is here, and
yeah, can you introduce yourself? Tell us what is your position in the department? And
Mr. Dupria is here.
Yes, I want him to introduce himself. What is he a consultant or is he a member of the department? And why an official is here and not a politician?
Good morning, Chairperson. I hope I'm audible.
Yes. You are. Proceed.
Good morning, Good morning, Honorable Chairperson and Honorable Members and Honorable Ministers. This is Ms. Kay Pillay. I'm the DDG Legislative Development, and we will be leading the presentation today. Our Minister is in another meeting, but is going to join this meeting very shortly. So, Chairperson, if I may start, Mr. Dupriya will take us through the presentation, and I will just introduce the presentation, awaiting the Minister's arrival on this platform.
You say he will be here for a few
May I
minutes.
proceed, Chairperson?
No, can you first listen to me? You say he will be here
He's
for
a few minutes late. He's going to join.
Okay, all right. I know, I accept that. Okay, fine, proceed.
No, he will be here in a few minutes. He's joining shortly.
Okay, great. Honorable Shibambo, you are answered now. Thank you very much. Let's proceed.
Thank you, Chairperson. Firstly, we welcome the opportunity to make this presentation to the committee insofar as the Land Claims Court is concerned. We await the opportunity to make a presentation to the committee on the amendment to Section 25 as per the Minister's request in a letter that was written to the committee. Today's presentation, therefore, is on the functioning of the Land Claims Court and how the challenges that have been identified will be mitigated in the Land Court Bill. With that in mind, Chairperson, we may flight the presentation, and that will be done by Mr. Henk Dupriya. Thank you very much, Chairperson.
Good morning, Honourable Chairperson and Honourable Members and Honourable Ministers. My name is Henk Dupriya, and I am the Legislative Development Section of our department. Unfortunately, it seems that I don't have administrator rights. So if we could possibly flight our presentation, please.
Mr. Duplessis?
Mr. Chairperson, yes.
Are you still
I still do not have administrator.
You don't have?
Beg your pardon, Chair?
What don't you have?
Honourable Chair, what I indicated, I don't have administrator. There we are. Thank you very much, Chair.
Okay.
I apologize for the delay, Mr. Chairperson, but could we possibly request the managers of this forum just to flight the presentation for us, please?
Advocate Romano, can you flight the presentation? Advocate Romano? Advocate Gwebu? Advocate Romano?
Yes, Chair, I'm trying to do that.
Okay.
Chairperson, the minister has joined us.
Thank you very much. Honorable Minister Lamola, are you with us? Honorable Minister.
Yes, Chairperson, I'm here.
Oh, thank you very much for your attendance. We received and accepted your apology that you would be a few minutes late. Do you want to proceed and open the presentation before the officials come in?
Yes, Chairperson, and I want to thank you for the opportunity. We did receive letters from the committee requesting us to make an input with regards to Section 25 in its broader sense, and also with regards to the Land Court Bill that we have submitted to Parliament. On the first aspect, Chairperson, we have got constraints as a department because we need to consult the Cabinet in terms of the amendment of Section 25 in terms of our input, which we are in the process of consulting so that we can make an informed input also that has been consulted with Cabinet. Because you will know that as an amendment to a legislation or to a constitution, it has to go through the processes of Cabinet. But on the second aspect, Chairperson, the Land Court Bill has gone through all the Cabinet structures. And we have finalized it in terms of Cabinet approval, and it has been submitted to the Speaker. We are at liberty to speak on it, and I'm with the officials of the department, led by Ms. Pillay, who is the head of legislative drafting in the department, who will be the one who leads the presentation. Broadly, the bill, Chair, seeks to cue the mischief that relates to the fact that the court, when it was introduced, the Land Claims Court, it was introduced as a temporary measure to deal with the land claims at the time as it was envisaged. But it has proven over time that those matters are long-term, and the court is still having a lot of outstanding matters, the Land Claims Court, related to the Restitution Act, in terms of which it was established. And also there have been challenges in the court, the biggest one being the fact that the judges that goes to sit in the court are the judges that are seconded from the various divisions of the High Court into the court. So this Land Court Bill now changes that and creates permanency in that court, and the DDG will speak to that. The second aspect also broaden the mandate of the Land Court to be able to deal with all land matters in the country. And our view is that will help us to develop land jurisprudence in regard to various issues of disputes, but it will also help us to deal with some of the issues that this committee it is currently dealing with in future, the expropriation bill and the issues that might arise as an outcome of the discussion of this committee, to bring certainty and legal jurisprudence into the public, into our court system. And the third aspect is also to introduce a court annexed mediation process in terms of alternative dispute resolution, so that a kind of labor relations framework, if you look at the CCMA, how it operates, so that land activists can participate and also make inputs into the court's process, but also so that the process is not over judicialized. It is going to be structured in the same framework as how the CCMA, the Labor Court, and the Labor Appeals Court is structured. So with that brief input, Chairperson, I will request that we allow the DDG to get into the details of the substantive of the bill.
Thank you, Honorable Minister. Mr. Dupree, you were on the platform. The Minister is giving you the green light to proceed. Mr. Dupree. Mrs. Pillay. Mrs. Pillay.
Yes, Honorable Chairperson, I can start with the presentation. There seems to be a problem with Mr. Dupree's computer. So if we may proceed to the first slide, the second slide, I beg your pardon. Honorable Chairperson, the request by the ad hoc committee has been requested to ensure that Section 25 of the Constitution is amended to explicitly provide for expropriation with nil compensation. The committee requested to be addressed on the challenges that are being experienced by the Land Claims Court and the relevant mitigating factors that's going to be put in place. The discussion on the challenges and mitigating factors follows below. The background to the Land Claims Court. The focus of recent discussions has been on the role and functions of the Land Claims Court, the court, established by Section 22 of the Restitution of Land Rights Act 1994, and also on the existing structure of the court and its jurisdiction. The current role and functions of the court: to adjudicate on disputes referred to it by the Commission of Restitution of Land Rights, the Commission, established by Section 4 of the Act, and it deals with matters on a referral basis, that is, matters which the Commission has not managed to resolve in its statutory mediation role. The court also has exclusive jurisdiction to deal directly with matters in terms of the land reform, Labour Tenants Act, and the Extension of Security of Tenure Act 1997. The court's focus, however, on land claims and restitution being a specialist court with limited and exclusive jurisdiction. The court does not have jurisdiction to deal with, for example, expropriation of land without compensation. To summarize the following shortcomings that have been identified that gave rise to the request that the Land Court Bill be promoted are the following. The single biggest challenge that the court is facing is its lack of permanence, which results in the court not functioning optimally. The current legislative framework owes its existence to the initial point of departure that the court would have a limited lifespan within which to deal with restitution claims. The reality, however, is that the land restitution process has been a very protracted one and is far from complete. The processing of land claims is slow and there are many backlogs. The current legislative framework has given rise to the situation where most judges are either seconded or appointed in an acting capacity. Further, matters dealing, the next slide please, matters dealing with labor tenancy status are dealt with by the court at its seat in Randburg, whereas restitution matters are dealt with by the court sitting elsewhere in the Republic as the need arises. This means that the parties in labor tenancy matters sometimes have to travel long distances in order to have the matters dealt with in Randburg. A further issue raised by the Office of the Chief Land Claims Commissioner is the reliance placed on pre-trial conferences in order to enforce compliance with the rules which are made by the President of the Court in terms of Section 32 of the Act. This, it is suggested, emanates from the informal nature of the court being a court of equity, giving rise in practice to relaxed compliance by parties with court directives, practice notes, which in turn gives rise to unnecessary delays. The Interministerial Committee on Agriculture and Land Reform mandated the department to prepare a bill that not only establishes a fully capacitated land court under its own founding legislation with jurisdiction to deal with matters currently dealt with by the Land Claims Court, but to broaden its mandate to also adjudicate on matters in respect of other land-related legislation, and B, further incorporate structures which encourage the use of alternative dispute resolution. To achieve the above, the IMC ministers and departments were requested to identify land-related legislation for inclusion in the bill, and also to identify the most pressing land-related legislation and the provision thereof that are suited for ADR in the form of mediation and arbitration. I move now, Honorable Chairperson, to the Land Court Bill. The Land Court Bill was approved by Cabinet for submission to Parliament on the 24th of February 2021. The bill, as approved by Cabinet, is currently being scrutinized by the Office of the Chief State Law Advisor with a view to provide the final certification of the bill. The Rule 159 letters were submitted to the Speaker of the National Assembly and the Chairperson of the NCOP on the 24th of March 2021. The broad purpose of the bill is to enhance and promote access to land on an equitable basis, promote land reform as a means of redressing the effects of past discrimination, and facilitate land justice. And for this purpose, the bill aims to establish a land court with jurisdiction to grant any order, any other appropriate relief, or impose any sanction as provided for in the bill, or any other law that confers jurisdiction on the court. B, to establish a land court of appeal to hear and determine appeals emanating from the judgments and orders of the court. And C, to provide for court-ordered mediation or arbitration. The next slide, please. The establishment and status of the court. The Land Court is established as a high court that has the authority, inherent powers and standing in relation to matters under its jurisdiction, equal to that which a court of a division of the High Court of South Africa has in terms of the Superior Courts Act in relation to matters under its jurisdiction. The composition of the court consists of a judge president, a deputy judge president, and so many other judges as may be determined in accordance with the prescribed criteria and approved by the president. The jurisdiction of the court. The court has exclusive jurisdiction in respect of all disputes that arise from land reform initiatives that are aimed at giving effect to Section 25 of the Constitution, and the Land Court will be situated in the area of jurisdiction of each division of the High Court. The court will also have jurisdiction to adjudicate on disputes arising from the expropriation legislation, insofar as those disputes relate to expropriation of land in the public interest. Provision is also made for the minister, after consulting with the Chief Justice, for the purposes of adjudicating land disputes and in the interest of access to justice, to define the specific area of jurisdiction of each court. The powers of the court. In short, the court has all the powers that a division of the High Court in the civil proceedings at the place where the land in question is situated. The court has the power to decide any issue in terms of any other law, which is not ordinarily within its jurisdiction, but is incidental to an issue within its jurisdiction if the court considers it to be in the interests of justice to do so. The court also has the power to reserve any question of law that arises in the proceedings for the decision of the Land Court of Appeal, and pending that decision, the court may make an interim order. The Land Court of Appeal. The bill establishes the Land Court of Appeal as a court of law and equity. Except for the Constitutional Court, the Land Court of Appeal is a final court of appeal in respect of all judgments and orders made by the court in respect of matters within its exclusive jurisdiction. It is a superior court with authority, inherent powers and standing in relation to matters under its jurisdiction, equal to that of the Supreme Court of Appeal as in relation to matters under its jurisdiction, and the Land Court of Appeal is a court of record. The Land Court of Appeal consists of the judge president of the court, a deputy judge president, and such number of other judges who are judges of the court or High Court as may be required for the effective functioning of the Land Court of Appeal. Mediation. If at any stage during proceedings but prior to judgment it becomes evident to the court that there is any issue which might be resolved through mediation, the court may make an order directing the parties to attempt to settle the issue through mediation, and that the proceedings be stayed pending such process. If the judge president decides that the matter must be referred for mediation, he or she must make an order directing the registrar to transfer the matter to the mediator. The order of the judge president must specify the time, the date, and place where the process is to start, and appoint a fit and proper person as mediator to chair the first meeting between the parties. The parties may, however, at any time during the mediation, by agreement, appoint another person to mediate the dispute. Chairperson, that is the end of our presentation, and I hand over back to the Minister for any closing remarks. Thank you.
Mr. Dupree is no longer going to make an input.
No,
Honorable
Chairperson.
Minister. Okay, Honorable
Yeah.
Minister.
Yeah, no, thank you very much, Chairperson, for this opportunity. Maybe what I could just add a bit is that you will see that the architecture of the bill is aimed that the court could be able to sit anywhere in the country. Because as you are aware, most of the land claimants or the people affected by the question of the land, including those that are residing in some of the rural areas and in farms, may not be able to travel to Randburg, which is the current sitting of the land claims court. It's aimed that the court can be able to sit anywhere in the country, so that it minimizes some of those kind of challenges. And the second point is that with the upcoming sitting of the JSC that is starting on Monday, we have requested through a presidential minute for the president to allocate the first two judges that will be permanent with the current system or architecture of the land claims court, but those judges will be directly be designated for the land claims court and also for this court as it becomes operational. And we believe that that starting process will enable to lay a foundation and a transitional period for as and when Parliament concludes the process of the bill and the President finally approves the bill. And we are also of the view that this bill will also be a game changer in terms of creating some kind of speciality on the land related dispute and related matters, akin to the tax court, akin to the competition court, and akin to the labor relations or the labor court kind of an environment, but with some bit of flexibility in terms of the ADR kind of dispute mechanism, and in that it may be able to help adjudicate matters with ease and with speed, and bring land justice to the people of our country. Thank you, Chairperson.
Honorable Member, Minister, thank you very much for being so responsive, because for the past 10 years, this Parliament has been complaining about the temporary judges in the land claims court, and suggesting that that is the source of the backlogs that are facing that court. And we are grateful that we have decided to address that matter with extreme urgency. But going back to your assertion that you still need cabinet approval for your comments on the amendment, we unfortunately cannot grant you such an extension, but I think we can accommodate you by allowing you to submit your comments as soon as they are ready, because anyway, those comments will be relevant to the discussion by the committee when it considers the bill. But we cannot have any further hearings from today, because next week we have got to finalize the report, and then we take the process forward. Honorable Ndozi, Dr. Ndozi. Honorable
No,
Dr.
Ndozi. Chairperson, it's really a follow-up. Yes, Chairperson, it's a follow-up on what you're saying, that how come other ministers have provided comment whilst the minister now in question says he's still waiting for for cabinet approval. It's really inconsistent, because it's not the first one we are listening to. Can we just get clarity on that? Thank you.
But he has explained, the minister explained that the process is that they must go to cabinet first, and that has not yet happened. Honorable
Please
Minister,
please don't put your words on his mouth. Let him answer for himself. Why are other ministers giving perspective and he is not giving? Did they seek a cabinet approval to speak? It's a basic issue that he must articulate a position on it, unless if it's a coward.
No, Honorable Shibambo, we mustn't go into that direction. We must go.
He's scared. He's scared. He doesn't want to take a position.
Chairperson,
No,
I'm not scared. I can answer.
Yeah, no, he will answer. Proceed, Honorable Minister.
Yeah, no, thank you, Chairperson, for the opportunity. If you look at the presentation we have just made, the Land Court Bill has gone through the process of cabinet, and that's why we are at liberty to speak. And if you look at other presentations by ministers, those presentations have gone through the process of cabinet, including the expropriation bill that Minister Delil was presenting on. They have gone through that process. So the issue of the amendment to the constitution, it's almost the same as the bill process. So we will have to get the inputs from our cabinet colleagues. Hence, we need that kind of engagement. As you are aware, this process has always been run in Parliament. The amendment, it has not been run from the executive perspective. So from our side, we are in the process of seeking those inputs of our colleagues in cabinet with regards to the amendment itself and the content. We have already kickstarted the process, and we don't have a problem with the ruling of the chairperson that we must make the input in writing if there will be no other sitting in terms of a verbal input. We will be able to do that. Thank you, Chairperson.
Thank you, Honorable Minister. Now we are quite sure, all of us, including Honorable Shibambo and Josie, that we are not afraid. You are just following the process, correct process.
There is pure cowardice. So we'll see what happens.
Okay, no, fine. Honorable Minister, before I open the floor for questions, can you just help us understand this? We have been made to understand that there is a panel of lawyers who act for communities that have lodged claims for land restitution from 1998. But some lawyers who are not on that panel have been acting for communities from 1998, and communities are not able to pay them, and they're still doing the work. And now they are told that these communities must go to the lawyers on the panel, but the bills that have accumulated still there. So can you just explain how does that system work? Because it will really create great unfairness on the part of lawyers who have acted for the past 20 years, and they're going to end up not being paid simply because someone has not placed them on the panel. And secondly, there's a tendency on some land claims commissions to impose CPAs on communities while communities want a trust, but in some cases they've allowed communities to use the trust. In some cases they refuse communities to use the trust, so there's no consistency. Could you maybe address us on that?
Chairperson, I'm not really sure with regards to the first question in terms of the panel. What I'm aware of, maybe Minister Didiza, if she's still on the platform, she could be better placed to respond to that, because there is a land rights management facility which is within the Department of Rural Development, which we are currently in discussion with rural development. There's a transitional process that it will be transferred to Legal Aid South Africa with effect from the 1st of April. And it is going to be a transitional period with regards to that panel. and Legal Aid South Africa is in the process of preparing itself, Chairperson, to appoint and also establish a land rights division that will be responsible for land justice to represent people with related to land matters across the country, because we believed that it is a better suitable institution because it has got presence across the country. It will obviously also at some stage during their processes, they may use obviously panels and so forth as they start the process that is already there with the land rights management facility. But with regards to the practicality, I think rural development might have a clear understanding because they've been the ones who have been running that facility for the past years. So I'm not sure whether the question relates in particular to those that belong to that facility, or it relates to the assistance that at some point Legal Aid was also able to provide, where in the division where they deal with the public interest matters. And on the
No, it relates to the facility, but I think we have dealt with the question very well. I think we'll refer the aggrieved parties to the Minister Dizidi. I think she'll be able to deal with that. So I think that is done. The second one was this imposition of the CPA on communities, contrary to the law, which gives communities an option.
Yeah, no, thank you, Chairperson. I think that is also something which the commissioners at the Land Claims Court are expected to interpret the law as it is envisaged by legislation. And this issue also cut across both the Land Claims Court and also ourselves and the Department of Rural Development, because the trust, as you are aware, are also administered by the Master's Office of the High Court. And I'm aware that the rural development has raised serious concerns, even with regards to the trust. There are issues that they have raised, in particular on issues of accountability, on issues of the re-election and of holding consistent election program for the trust and the trustees, and also with regards to the beneficiaries. So there are also challenges there with regards to the trust. But with regards to the question of the commissioners, they are expected to implement the law as it is presented to them by the crafters of the law. So maybe that there could also be an addition from rural development, in particular on this aspect. Thank you, Chairperson.
Honorable Minister, you have covered me very well. Thank you very much. We'll be able to advise the communities that have challenges in that regard. Honorable members, I want to open the floor for questions. I see Honorable Swart. Proceed, Honorable Swart.
Thank you, Chair. Thank you, Minister. I appreciate, Chair, your questions about the legal aid and the panel of lawyers. That's an issue which, when you were Chair, remember we dealt with that and there were great concerns. So I'm pleased that there is some progress in that matter. I think the funds in that, from that department, we still wanted to go to Legal Aid South Africa. I think that was helpful. But I just wanted to ask, whilst we appreciate, I think the Land Court Bill we will be dealing with in the Justice Committee, it looks like it's a step in the right direction. But I did want to ask the Minister, maybe just at this stage, the relationship between the Supreme Court of Appeal and the Land Court of Appeal. I would like just to unpack that slightly, understanding that it is a bill that we will be dealing with in the Justice Committee, but just that relationship between those two appeal bodies, appeal courts. Thank you. I think you're muted still, Chair.
I say you are right that the Minister is responsive when he dealt with these matters very well, because we spent 5 years calling on the department to make sure that the legal aid South Africa be involved, and there was no progress. So we are really grateful that the minister is attending to these matters. I see Honorable Mwaseta's hand.
Chairperson, good morning, and all members of the platform. Chair, I have got just a clarity-seeking question directed to the Honorable Minister Lamola. In our interactions during the process of our public hearings, notion has been coming and going with regard to suppose a dispute arise. And the two versions which became a bit famous were such dispute, in order to expedite matters very quickly, could either be addressed at the level of the executive or at the level of the judiciary through the courts. I wanted just to find out from the Honorable Minister, from the position where he is, which one could be able to speedily assist should any such dispute arise. Could it be quicker if it goes via the executive, or be quicker if it goes through the judiciary? That's my question, Chairperson, and thank you very much.
Honorable Minister, I think one leg of what Honorable Wasatha is raising is that for matters to go to the minister, they must come through the land claims commissions. And people complain that the land claims commission actually are a barrier to accessing the minister. So if you can just address that aspect that Honorable Wasatha did not raise.
Thank you, Chairperson. I have heard two questions from Honorable Swart, and the last one. The first one from Honorable Swart relates to what will be the relationship between the Supreme Court of Appeal and the Land Court of Appeal. The relationship, Chair, it will be akin to the relationship that currently exists between the Labour Appeals Court and the Supreme Court of Appeal, and also the Competitions Appeals Court and the Supreme Court of Appeal, is that this appeals court will be the almost equivalent to the Supreme Court of Appeal, meaning that the decision from that Supreme Court from that Land Appeals Court will have to then go to the Constitutional Court if there is a constitutional matter that may arise, and if there is no constitutional matter, it will be the matter will be final. Of course, these are issues that have been debated by our courts in terms of jurisdictions, and we had also sought legal opinion with regards to the issues of exclusive jurisdictions of the land court, and we acknowledge that there could be issues of contestation, but from the perspective of drafting and how it has been presented, we have tried to resolve those kind of issues. On the second question, Chair, it directly relates to our first request that the issues that relates to the direct amendment of Section 25 will request a consultation with Cabinet. Firstly, is that if you look into that, the first issue is that there must be a decision to expropriate that must be taken through that consultation between the Land Commission and the executive authority of the department that will want to expropriate. So what then should be separated is the decision to expropriate, and also what will come out of the decision to expropriate, which might be the objection or a dispute by the parties that are involved in the expropriation, the expropriatee and the expropriator. So the aspect that relates to, firstly, the decision, it will have, obviously, that is the part where the executive will have to decide that it must be a decision of the executive that we are going to expropriate in this area in the public interest, and this is an issue. And if there is a dispute that may arise, it is then that this process of the land court may kick in terms of the mediation and all the related aspect of the court. Thank you,
Honorable Minister, to the best of my knowledge, the Restitution Act was passed before the new constitution. Are there any intentions to amend that act to align it with the new constitution?
Chairperson, I think what I can respond to, maybe I'm not sure if Minister Didiza is still in the platform. Firstly, is that on the first question that you raised about Legal Aid South Africa and the land management facility, we are working very well and we are in the process of transferring it to Legal Aid South Africa. On this question in specific, you are asking me, it is related to the Department of Rural Development in terms of whether there will be an intention to amend the current Restitution Act to be in line with the Constitution. But to the best of my knowledge, the Restitution Act was adopted after 1994 to address some of the restitution matters and so forth. But rural development will be better placed in that. What ourselves can respond to is the fact that you will know that the Land Claims Court came from the Restitution Act. So this act will amend that aspect of the Restitution Act, which deals with the Land Claims Court. That is what the land court bill will do. Thank you, Chairperson. So the other aspect relates to rural development.
No, Honorable Minister, you have covered us because we also appreciate the fact that you and Honorable Didiza work together. So nothing will fall through the crack. So we don't have to ask her to come to the platform if she's not there. I think we are covered. Honorable Muraseta.
Yeah, maybe Chairperson, just as a follow-up to the question that what in principle, or who is fit and proper person to sit as a mediator in any land dispute? Could we be referring to pastors or lawyers or even doctors? Who precisely could be relevant to sit in such dispute, if I were to make a follow-up and ask?
Okay, Honorable Minister. Honorable Minister.
Thank you, Chairperson.
Yes.
Proceed, Thank you, Chairperson. What we have done in the process of developing the bill, we consulted with the CCMA, which has got almost a similar kind of arrangement that we're trying to create, to see who are the people who sit as commissioners in the CCMA. It's a variety of skills that are there, from labor relations practitioners, and others were not really trained in the field of in terms of being lawyers, but they came through the ranks, for example, of the trade unions. But they've got skills, expertise, and experience, and some ended up. They've also been trained in mediation. So as we started the process, Chairperson, we thought of doing it fully under the auspices of the CCMA and just create a chamber within the CCMA because they already have expertise on this matter of mediation. But the CCMA raised concerns about budgets and the issues of the house to say maybe we should start separately and we can learn from them as we move forward and we can find a way of the structures sharing experiences so that the chamber that we're trying to create of alternative dispute also learn from the experiences of the CCMA. So one of the biggest lessons we've learned from the experiences of the CCMA is that the practitioners at the commissioners at the CCMA who are dealing with mediation and also arbitration, they themselves are mediators. They are trained mediators. They can mediate in any dispute, not only labor relations related dispute only. They can mediate in any kind of a dispute. So that is the experience that we have now learned from them. And we are the incorporation into the bill will allow us to get trained mediators who will be qualified, who will be able to resolve any kind of a dispute. But on this matter, with specific emphasis and speciality on the land matters, because our intention is to create a speciality on the land matters from the mediation level, arbitration, the court level, and the appeals court level, and it up until the constitutional court. So that is the seamless kind of way we want this to happen, and such people will be trained in the field of mediation with more emphasis on the land dispute matters, Chairperson. Thank you.
Thank you, Honorable Minister. Honorable members, I don't see any new hands. I think the minister has discharged himself very well, and I think we should release him and move on. Can we release the minister and his team?
Chairperson?
Yeah.
No,
Advocate?
no, I'm just informed that you are too close to the camera and the meeting is live. They can't see it properly.
Oh, I'm too close to the camera.
Yes.
Am I fine now?
You are perfect now.
Okay, thank you. I was just asking honorable members if it's right, okay, that we release the minister and his team. I think they have met our requirements. There's no opposition to that. Honorable Minister, thank you very much and keep up the good work. I think you are doing what we have failed to do in the past 10 years and you are doing it very well. Thank you. Bon voyage.
Thank you, Chairperson, and to all the honorable members.
Thank you. Honorable members, as I said, now we have completed the last leg. We have completed the last leg of our hearings. Now, what remains is that the final and comprehensive report should be produced. And I want to suggest to the administration that that report should be available the latest by Tuesday next week. And that the report must be sent to all political parties. And on Friday next week, we convene to consider and adopt that report so that now our focus can turn to the discussion of the bill amendment bill itself. And I want to believe that in the interim, all political parties will go to their principals to seek mandates, on the substantive issues that will arise from the report. And I also just want to thank honorable members for the fact that we have reached this stage without having to vote and with the full participation of all political parties. So I think that this process
point of order, man.
This process, Honorable Dr. Ndlozi, we will send you to medical school so that you can help them. So, honorable members, I'm just saying that it is quite clear that this process is within your capable hands, and you have discharged yourself very well up to this stage. And now, after next week, we'll move to the stage of considering the bill itself. And I have no doubt that we will be able to complete our assignment by the 21st of May. And I really thank you for the cooperation amongst yourself, the cooperation with the chair, the cooperation with our very competent officials who have never let us down throughout the process. Is there anyone who wants to say something before we adjourn the meeting? I don't see any hands. And I, therefore, with your permission, would like to adjourn this meeting and request the administration, the report must be available the latest by Tuesday next week. And we convene on Friday to consider and adopt the report, and then also adopt the final roadmap, which will take us to the conclusion of this process. I thank you very much. The meeting is adjourned.
Thank you, Chair.
Thank you.